Welcome back to the Business Immigration Benchmark. Again, we're in our summer schedule, so delivering episodes in between vacations and relaxation. Hope you're doing the same this summer. Today, we're going to talk about an evergreen issue, which is the impact of termination or restructuring layoffs on a foreign national and a work sponsored visa status. With that, let's dive right in. This one becomes a complicated issue when an employer terminates or is thinking about terminating or restructures and effectively needs to terminate employees who are subject to an employment based sponsorship visa status. There are different buckets in the compliance obligations for employers who are laying off visa sponsored employees. The first and most important category of folks to be considering if you are going through these types of layoffs. And often global mobility is sort of second in the conversation to hear about these restructurings, but you want to make sure anyone in H-1B status has a very specific conversation or that the team considering laying off H-1B workers knows about the compliance obligations. The first is that if you are laying off a H-1B worker, you have to notify USCIS of the layoff. That is a requirement to compliantly effectuate the termination and an exit requirement, so to speak, for the company to exit the sponsorship of the H-1B workers. The first is not only notifying the employee pursuant to your employer practices, all of the state rules for lawfully terminating an employee, but then also notifying U.S. Citizen Immigration Service of the termination of the H-1B employer. The second is that the employer must offer reasonable costs of transportation to return home. So this is an airfare for the H-1B worker. This is not airfare for family members. This is not airfare for transportation of goods, but airfare for that H-1B worker to return home. The best practice here that we recommend to our clients is to document this in writing. So that might be a follow-up email, that might be something in their packet of information that you are providing them at their exit conversation where the offer is being made and the H-1B worker has to return some sort of answer, whether they're accepting the return airfare home or whether they're declining. So the company need not pay if the employee does decline, but you'll want some sort of documentation. If those two things don't occur, the USCIS, or rather, the Immigration Service, does not consider that H-1B worker lawfully terminated, and that means your employer or the company may be liable for back wages. So something you definitely need to build into your process when exiting H-1B workers in your company. Now, your company may sponsor other statuses for foreign national employees, most commonly L, TN, O. There are no repatriation requirements for those foreign national individuals if the employer does terminate those, but you want to make sure your record keeping is clear in your systems and that having the documentation, of course, is critical. And of course, you want to be compliant with your state employment rules. One question I commonly get when a company is going through restructuring and layoffs, which is common right now, we're in that economic cycle. I get the question from both HR and employees about, well, when does the grace period start? And the grace period is this 60-day period that starts the day after the last day of productive employment. That is what the regulations state as when the grace period starts. And that grace period is 60 days. Or if the foreign national's I-94 expires before the 60 days, then they don't get the full 60 days. So we always recommend if an employer is actioning the termination for the foreign national employee that the employer offer an exit consultation with immigration counsel. Reason I recommend this is we don't want HR or the employer making statements about the individual's personal immigration compliance because they're not the expert. And if the foreign national employee who's being terminated relies on the guidance of the company's HR or manager and it's wrong, well, it's a real big disservice to that employee, and that employee may come back and blame the company for relying on the bad guidance. So you don't wanna be in that situation. You also want some separation here in the unfortunate situation where you are separating from the employee. You wanna make sure that that foreign national employee has a very clear picture of what their personal immigration compliance is, and also having that separate conversation, it's a very good pathway for the foreign national to understand that there is separation from the employer's continuation of maintaining that status on behalf of the employee. So those are sort of key things that come across in the exit consultation that you want to make sure are happening for, the foreign national employee to maintain their immigration compliance, which there are also personal pieces within that 60-day grace period and beyond that foreign national employee is gonna wanna be thinking about that is separate from the company post-termination. I get a lot of questions about what if I have severance or I have a non-compete. Discuss those issues a little bit, at least the non-compete on a previous episode here with Lisa Dolge, an employment attorney expert in the non-compete space. If you are an employee in that situation who has a long severance or is subject to a non-compete, you are gonna wanna engage a personal immigration attorney to advise you on what you should be doing for your immigration compliance. Again, an exit consultation from the employer's attorney is really gonna be quite brief, but is gonna, set you up and make that recommendation, honestly, to start working with a individual immigration attorney to advise you on those more nuanced and complicated issues. I get folks that my friend had severance and, that extends the grace period. It doesn't. And, again, this is not legal counsel, but if you are in that situation, you're going to want to seek legal counsel to ensure that you have the compliance guidance that you need to stay lawfully present in the US. Under this administration, one thing I can tell you for sure is there's no gray area and there's no leniency. So I would not be relying on Reddit posts or guidance from your friend who did it 2 years ago. That doesn't apply, and you shouldn't consider that guidance to rely upon. Of course, with a termination, there's also going to be green card implications for the employer. If and depending on where the terminated employee's sort of green card case is, you're gonna wanna look at whether it is something you withdraw from the DOL, and what kind of open case liability your company is or is not willing to sort of deal with. So make sure you're working very closely with counsel to advise not only on how to manage the specific ongoing case for the foreign national employee, but how layoffs impact the foreign national green card program and your company's ability to sponsor green cards for other foreign nationals in your mobility program. This is something that we've talked about before, but that layoffs really do have some significant impacts on the company's ability to sponsor green cards through a labor market test. We see a lot of headlines, and one just recently is Microsoft is laying off thousands of workers, and then months later is laying off thousands more workers. The ability for a company like Microsoft to sponsor foreign national workers is effectively gonna be stalled with some exceptions for at least 6 months, and that the sort of rolling layoffs really impact, again, the timeline for many foreign nationals to seek green cards. So there's sort of two-step analyses you need to work very closely with counsel, both on the individual's case and how to navigate closing the foreign nationals green card case in addition to any exit compliance requirements like for an H-1B worker. And then looking at the program as a whole of how layoff of US workers impacts the company's ability to sponsor foreign national employees. The other thing that I wanna just briefly touch on to wrap up here is not just sort of the legal compliance and risks that you have to manage when exiting a foreign national employee, but also how it's being communicated, and this is, like, sort of the softer, sort of more squishy piece about communication and supporting, the sort of retaining population as well as the exiting population to protect your company's brand for your ability to maintain the talent, as well as to recruit new talent when you're out of this economic cycle. and things run in cycles. But, how are you communicating to the employees? Like, are you offering those exit consultations for the employees that are departing the company? And then how are you navigating the conversations for the employees that are retained with the company, both US workers as well as foreign nationals? Now, the foreign nationals that are retained are going to be very nervous about their ability to retain their status, their ability to secure a green card. And so, what communications are you thinking about putting out in light of those actions? And what can or can't your company do after layoffs and restructuring for the retained employees? These are things that you obviously want to work through with leadership within your company. What's the right tone for those messages, as well as what's legally permissible to communicate from like a state law perspective, employment perspective, and immigration law perspective. So a lot to think about. Again, this is an issue that is often comes up and especially comes up in this economic cycle. So if you've got any questions about, the bright line compliance requirements, reach out to your immigration counsel to walk through that to make sure your company has processes in place to remain compliant, as well as, programmatically how restructuring and layoffs impact your program and how you can navigate through. Because it's going to be a tough cycle to navigate green card programs for the next several months. And then how are you communicating that for employee retention and future recruitment opportunities? Hope this was helpful. Thanks for tuning in to the Business Immigration Benchmark. We'll catch you next time.